Hi, everybody, and welcome to Raw Law. Raw Law. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and I'm just fresh off a trial. We were on trial on Monday, and we ended up settling the case. So I could talk a little bit about that and answer any questions, but it's nice to be back in the office. It's nice to be back in the swing of things, working on other cases, because I felt like it was a little bit of a whirlwind because I was away in California for a Trial Lawyers University summit where we learned about trial skills. And actually, I was one of the presenters. I gave a speech called The Turning Points of Trial on another trial that I did in August of 2023 of last year. And there were a lot of excellent lawyers there, very, very interesting. They were teaching about nursing home abuse cases where there's a negligence in nursing homes, for example, bed sores, or where patients get lost, and it's known as elopement, and patients just like disappear because they don't have the security protocols, or when a patient calls a nurse or a doctor, no one comes, and the patient tries to get up and falls, breaks a hip, all these types of cases. And they had lawyers that obtained amazing results in nursing home cases. For example, the presenter, I think, had a case for like $44 million, and he was teaching this. So it was very, very interesting. Very, very interesting. So, yeah. Okay. Okay. So let's see. Let's see what questions we have here. Okay. Let's see. I'll put this on the live chat function so everything is visible. Chris says, hello, thank you for your videos. Oh, thank you. Come along with Uncle Joe says, not on. Oh, now you're on. And CC says, we can't see you. Can you see me now? Is it working now? I have this camera. I don't know, just like a finicky camera. It goes in and out of some kind of AI camera, artificial intelligence or something. But you could hear me, but you can't see me. I don't know why that is. It's weird because it's showing me the it's interesting. It's showing me the I don't know what it is. I might have to. Oh, someone else says we see you clearly. Oh, okay. So maybe it's working for some people and not for others. I don't know what it is, but I'll try to fix it if it's an issue. Sorry about that. I'll try to fix it. Okay. So yeah. So basically, let me tell you a little bit about the trial that I did. And what we'll do is next week, I'll do another session with Mr. Mogg, Richard Mogg. He helped me with the trial. We worked on it together. And so maybe he can come to my office and we can do a live session where we answer questions or we talk about the trial. Because even in that trial, even though it didn't really happen, we had prepared for trial, we were ready for trial. I actually workshopped the case at a lot of these continuing legal education events with other lawyers, but we never actually conducted the trial because what happened was they had offered some money and then they went up and then they kept going up and up, and we had a mediation, and then at the mediation they said, this is the most we'll ever pay. And we said, okay, fine, so let's just go to trial. And then at trial they paid much, much more than that. Yeah, almost $1 million more than they said they would ever pay. But anyway, but then they got to a certain number and it was a fair number. I mean, I felt like we could still get more and I wanted to push for more. But the client and the client's wife kind of decided that, hey, maybe it's not worth the gamble, because the defendants also said that if we were to pick a jury and start opening statement, that they would take the money off the table. And that's a trick that they sometimes use. Now, I've never really seen that actually happen. I've heard them say it. Oh, look, we're giving you $1 million. If you don't take it, we're going to take it off the table. Have I ever actually seen them take it off the table? Pretty rarely, maybe like once or never. It's kind of like a trick. But I can understand that it would work and people would get scared, and it was a significant amount. So, I mean, long story short, the case ended up settling for $2,200,000, which is a pretty good result. And I'll talk about the case, in greater detail, maybe in another video. And like I said, I'll have Mr. Mog on. And there's a lot of different things we could talk about with that case. There's the voir dire, the jury selection. We had like a really interesting voir dire. We had like these funnels where we would get the jurors to tell us like what our principle is and get the jurors to tell us what our fears should be. We also had different questions, different areas of exploration. Then the opening statement. We had like different parts of the opening statement, the defendant's story of what they did and how that caused the injury, and then the plaintiff's story in detail. And some of it was like, some we had some animations, reconstructions, videos, very, very interesting. And then we had a whole witness list lined up. We had both went and prepped the doctor. It was a spinal surgery case, a lumbar fusion. So we prepped the surgeon, and we went to his office on a Saturday. So we had a lot of information from that, and from um, we had, of course, like a circle of friends, witnesses. So it's a little bit detailed. So I'll do another video about that. But I was happy that we got a good result. Okay, let's see what questions you have. Um, okay, Gerald says, I wanted you to make more videos on spinal cord stimulator cases and verdicts. Yeah, absolutely. I just did a video. It's not out yet, but I just did a video on electrocution cases. Like, for example, fires, burn injuries, electrocutions, and explosions. I noticed when I was out at the Trial Lawyers University, a lot of lawyers are handling these cases. And one lawyer that I was very friendly with, actually out of Las Vegas, he had a case with an electrocution. I believe it was like at a Las Vegas casino or something, or a hotel casino, and it was like an iron, and it was like a $21.7 million verdict. So I thought that was amazing. So I invited him to our channel to say, "Hey, come on the channel. Maybe we could talk about the case." And so he said he would get back to me. Maybe we could schedule that. And just in general, like electrocution verdicts, settlements. And in the same vein, yes, spinal cord stimulator as well. Now, spinal cord stimulator is an implant that they'll put in response to a variety of different types of injuries if the doctor thinks it'll be helpful. Usually it could be after like a spinal fusion. So yeah, we could do cases. I don't know if we'll be able to find cases just with spinal cord stimulator because, like I said, because it's done as a type of implant or a type of procedure for like a variety of different injuries. You're going to have different injuries, so you're going to have probably a wide array of verdicts for the spinal cord stimulators. But I'm happy to do that, and I could also review that the verdicts, because sometimes if I try to do a verdict search video without really reading all the cases and outlining them, it becomes a lot. It's like drinking from a fire hose, right? Because like each case has so much information, like how long they deliberated, all the little nitty gritty. And then if I try to like read it while I'm live and go through it, I might only be able to get through like three cases that in like an hour will go by, unless I skip things over. But then, so like I said, so maybe what I'll do is I'll review it in detail, make an outline of the most like salient, interesting points that I think you guys would enjoy, and then do a video about that. So that should be better. Okay. And then Mo Money says hi. Uh, and let's see, what other questions do we have? Baby boy Jody says, what happened in a personal entry case after a deposition? Okay, so yeah, after a deposition, so deposition of the plaintiff is when the defense lawyer, who's hired by the insurance company, asks you questions like, how did your accident happen? What happened? What are the facts? And the reason they ask you that is they want to establish liability, whether they are liable or whether you may be liable, right, or at fault, or whether a third party is at fault. And so they ask you that. And then they also ask you about your damages, your treatment. Are you going to the doctor consistently? Is there like a big gap? Let's say like, a year where you didn't go to the doctor at all? Because if there is, they're going to use that against you and say, look, if you were really hurt, how come you didn't go anywhere for a year? So things like that. They're going to ask you, what are some of the things you can do, can't do? And in terms of after that, so after that, they have a lot of information, right? Because they have the transcript of your deposition. They have all that information. So based on that information, they should be able to then offer you a settlement. And if it's a fair settlement, you could take it. And if it's not fair, if it's too low, you could say no, thank you, and push for trial and or another mediation. So it just every case is going to be different and distinct, but that's usually like the major first step is the deposition. Okay. The hire says, so they gave an extra $1 million to settle. Yeah, I mean, like it's a funny story. I mean, I could tell you like just briefly. So what happened was this client had another actually this client was a YouTube viewer, right? He found me on YouTube, like you guys. He was a viewer. So he was from the Bronx and a very nice guy. And so he had this other lawyer, and this other lawyer got him a settlement. I think the offer was like about 200,000. And the other lawyer was telling him, "You got to take this money, come into my office. The case is over. Congratulations." He was like popping champagne, saying like, "Take 200,000." So the client shows up with his wife, and the guy tells him, "I have 200,000 for you." And then meanwhile, the client has like a lumbar, fusion surgery, a serious back injury. So the client says, that seems a little low. I don't think, I don't know if he got it from watching my videos or from somebody else, but he just thought like, this is low. Why am I taking 200,000? And the client happened to be from the Dominican Republic. So this lawyer, what he does is he goes, okay, okay. He goes outside his office. He gathers up like a bunch of other lawyers in the firm, his secretary, I don't know, gets like 10 people, leaves the door open. Now the client and his wife are sitting in the office, and he says, can you believe it? Can you believe this client is not taking $200,000? That's so much money. And it's so much money in the Dominican Republic. And, his wife got like really upset about that. And I think justifiably so, right? Because they don't live in the Dominican Republic. They live in New York and they've been living in New York for like decades. So they thought that was a little bit like racist and insensitive and also kind of getting him to take such a small amount and pushing it down his throat, 200,000. So long story short, he switches over. I take the case, and this is already at a stage where all discovery is done. The case is on the trial calendar. We, of course, changed the case tremendously. We put a economist on it, lost wages. We did a 3101D, which is an expert exchange for the proper surgeon. We put a radiologist on it. We had, we've actually had over 2 million just in economic losses from our doctor and our economist working together. So we did a lot, and we prepped the client. We found these community witnesses. But long story short, in terms of the negotiation, so yeah, they were at 200. Then they went to I think 700. Then they said let's do this mediation. At the mediation, they said 1.2. Then they said 1.5, and that's final. We'll never go above 1.5. This was just like 2 weeks ago at the mediation. We said, okay, fine, let's go to trial. And then right before jury selection, they gave us 2.2, so 2,200,000. And at that point, they said, look, if you want to push forward, I thought it was worth more because of the surgery he had and the impact to his life. I thought like for a jury verdict, we could have had a shot to get maybe 7 or 8. But, of course, you have that issue with they're going to appeal. And then the appellate division may say, hey, do another trial or reduce it to like 2 or 3 or whatever they reduce it to, right? So then you're risking that. But I mean, and then they said, we're going to pull the offer, right? The offer is going to be off the table. And so at that point, the client didn't want to risk that. He said, I don't want to gamble. That's a lot of money already, especially compared to the 200,000 that was being shoved down his throat before. So all in all, it settled for 2.2 million, which I thought was a good result. Yeah. To answer your question, so almost $1 million more, 700, right? Because they were at 1.5. Well, 2 million more from the prior lawyer, right? Because 200,000 to 2.2, but from the mediation, 1.5 to 2.2, so 700,000 more for the mediation, or a million if you count their first offer, because their first offer was 1.2 and it settled for 2.2. I guess it depends how you look at it. And Jarrell says, what if they offer one lowball offer but didn't offer nothing else? Well, you just have to push them. You just have to be confident. The way I like to do it, that I've talked about in many videos, and I have a whole template of a letter that I do, and the letter is like 12 or 15 pages long. But now I'm thinking like you don't have to make it that long. You can condense it and make it a 1 or 2 page letter. Just boil it all down. Really, essentially, it says, pay me, for example, $1 million by July, 13th, 2024, in 30 days, right? Today is June 13th. So in July 13th, in 30 days, pay me by 5 p.m. $1 million. And I'm not just making that up, right? $1 million because, you have $1 million policy and here are my injuries. I have a fusion, I have a traumatic brain injury, whatever it is, a disfigurement, a burn. Here's all the evidence. Here's like, if you need witnesses, I have, their friends, their family, their coworkers. I have doctors, you give them everything. And then if you don't, that's fine, but I'm ready for trial. I'm preparing the case for trial. But at trial, once I pick a jury and once I do the opening statement, I'm not going to be talking to the jury about 1 million. I'm going to be saying that civil justice in this case is 3 million. So, kind of like pick your poison. You could settle it now. Here's your window of opportunity for these 30 days for 1 million. Or if you choose not to, then we're going to go to court, but then it's going to be 3 million. And then you just have to stick to your guns. Don't bluff, because then they'll call your bluff and they'll see that you're not a real player, like not a real trial lawyer. So just, stick to your guns, and you should be okay if you have a good case. And then Mo Money says car doesn't car does not show a lot of damage, but it's internal damage. The shop charged the defendant's insurance $6,500 and they paid for it. My question is, can the defendant insurance argue it didn't cause the surgery? Yeah, I mean, they always argue that. Of course, they could argue that it didn't cause the injury, right? Their doctor would have to say that from a reasonable degree of medical certainty, based on my examination of the patient, based on my review of the property damage, I believe that this impact did not cause the injury. And then your doctor will say it did, and then it's like a battle of the doctors. Sometimes they also have a biomechanical expert, which they had in this case that I just settled. They hired it at the last second, like on the 11th hour, not even a report, but they hired this biomechanical expert to say that the forces involved were not sufficient to cause an injury. So, based on the description of the way that the injury occurred, this was like a little bit of a different injury. I'll get into it in the video, but it wasn't like a car crash. It was a car incident. It was like the guy was driving his car and there was like a Con Edison manhole, and the manhole it was loose. It wasn't attached properly into the access, the hole where you go in, and like you have electrical wires and people, like a manhole has an actual hole where people go into the hole. But so the cover was loose. And so when the car drove over it, the cover like popped up. So that's what happened. Like the cover popped up like this, like at an angle, like at 45 degrees. And so the car drove up on it. The car's going like 15 miles an hour. Car flies up in the air like 2, 3 feet and then crashes back down. And he hits his head on the roof and he hits his lower back into the seat. And that's how he has this, herniation in his lumbar that he needs the fusion for. And so they said, look, this was a small little, like hitting a pothole. You can't get, um, you know, you can't have a fusion because of this. And they had a biomechanical expert. So yeah, that happens a lot. And we had our own, but we wouldn't have even gotten one because honestly, like I think the whole thing is junk science. I don't know. But I just got one because they had one. I figured if they have one and we don't have one, then we're kind of like we don't have an expert. They do. So we got one too. But ultimately, I think the judge would have precluded it because in this kind of case, the reason that a biomechanical expert could testify is because they could say, we based it on studies, like actual medical and scientific studies where, let's say, we examined, I don't know, like 1,000 people, and we had these like low speed crashes at 10 miles an hour, and then out of 1,000 people, only like 50 got hurt, but 950 didn't. Therefore, it's statistically improbable that you would get hurt. But see, no one would do a study with a car going up in the air, right? Unless you're Dukes of Hazzard or something. It doesn't exist. So that's why I think that whole thing would have been precluded because it's not scientifically reliable. There are no studies. If it was a low speed car crash, yes, there are a lot of studies on that. But you can't apply the low speed car crash cases with little fender benders to like a guy going up in the air 3 feet, right, on a ramp that's having his car thrown up into the air. It's completely different. And so I don't think it was scientifically reliable. That's a Daubert type case, or Fry. They do Daubert or Fry hearings to determine what's admissible. So I think that would have been excluded. But even if it wasn't excluded, it wouldn't have really hurt us because, I mean, the guy's coming up with this opinion at the 11th hour. This is a 2018 accident, right? So like 6 years ago. And he's coming up with the opinion in May of 2024 without going to the site, without ever, speaking to the client, without reviewing anything at the 11th hour just to help the defense, So I think it was weak. Yeah. And then Wayne says, enjoyed the video on EDRs. It's sad that I only find out about EDRs almost 2 years after the crash. My former attorney failed me on that. I hope the data is still there and can be downloaded. Yeah, definitely. It should still be there. Hopefully, if they preserved it, you should try to get that and have an expert review it. Yeah, I know an expert here in like this in Northeast that's pretty good at reviewing that. And Jeff says, how do the policy limits work when two people are injured in the same accident? Yeah, so usually, like, when you have a crash like that, they'll actually have limits so that, like, for example, if it's 100, 300, that means it's 100 per person. So if there are 2 people, each person could get up to 100. And then the 300 is how much they have for the entire crash. So let's say there were 4 people, well, the 4 people would then have to share the 300 because that's how much there is for the incident, for the crash. So, but it's usually like 100 per person. The first number is per person, the second number is for the incident. So it could be like 250 over 500, or it could be something else. But usually you see like 2550 or 100 300. Those are pretty common. And Mike says, hello from Griffin, Georgia. Hi, how are you? Thank you for being here. Yeah, we actually are doing a few consults in Georgia, a few different consults um, near Atlanta. And today I spoke to somebody near Savannah. So yeah, we were actually shooting a little bit today with our videos, and we had a few interesting videos where people did consult calls, and they agreed to, allow us to like record the non-confidential portion. So just kind of like the question, the general question, and the general answer without getting into anything like lawyer names, doctor names, obviously person's name or age or anything confidential. And I thought it could be interesting, maybe a future video we could edit that and then use it, and then it would be like how a lawyer does a client consultation. So we might post that later on. It should be interesting. And Chris Yaster says, what kind of lawyer would someone need if they have experienced racial discrimination from their doctor? Oh, I see. Discrimination from the doctor. I think that might be like a civil rights type lawyer. Civil rights, or yeah, probably civil rights. Actually, at this TLU Beach, they had a whole masterclass. So they had a masterclass on employment with this guy from California who had also like some kind of $50 million employment verdict. They had civil rights with a lawyer who had like also like, I forget the numbers, but it was high, like 40 million, 36 million civil rights case. And then they had this nursing home case. I did the nursing home, but the other ones were recorded. So maybe if I have time, I'll try to go back and watch the other ones. They're like 2-day master classes, so they're a little long, probably like 8 hours a day, but they have materials. So they have like the actual materials, trial transcripts, and then the lawyer goes through everything and explains it. Because I just wanted to like, educate myself to know a little bit more about how these other cases work as well. And then Jarrell says, what are the limits if they have a commercial policy? Yeah, so commercial policy is good. That means that the limits are probably high. There's not like one limit for all commercial policies. They're all going to be different. Like, for example, commercial trucking under the Federal Motor Carrier Safety Act, it has to be at least $750,000. Most are a million. Some are a million with like a 5 million excess. And the same thing with commercial vehicles. You have a van or a commercial car. Some will be a million, some will be a million with a 5 million excess, or umbrella, or whatever, what have you. So they're all different. You just have to find out how much they are in your case. And then the hire says, what's the latest in litigation that the defense attorneys offered a settlement? It could be, well, like this case, right? They offered it at the very last minute. They offered it at right before we were picking a jury. So that's probably one of the latest. I had it settle actually after the trial. So we had the whole trial done, and the jury was deliberating in the room, thinking about what the verdict would be as to the liability question. And then if we won on liability, it would go to the damages. We would do another trial on damages. It was bifurcated. So they were thinking only about liability. And while they were thinking about liability, the judge, spoke to the defense lawyer, who spoke to the adjuster or the person, the money person, and then the case settled. So it could settle even after the trial is over, anytime, really. Okay, and then Brooklyn says, "Is there 2550? Is there any way to get more?" Yeah, 2550 usually not, because that's the minimal. So if you have the minimal, then probably you don't have assets or excess umbrella. Usually the excess umbrella is going to be with 250,000 or more. So if you have a 250, you might have a million excess. That's usually how it works. And Steven says, "Hey, Arkady, thanks for helping me in my time of need." Yeah, absolutely, absolutely. I think I put him in touch with a few lawyers in his state where he needed him. Absolutely. I'm happy to do that for anybody. Just text me 347-566-9595. I'll just, schedule a call. The only thing I ask is when you text me, just tell me the facts of what happened. Just one or two sentences so I could almost like see it happening. Tell me the injury, I mean, if you don't have a diagnosis, if it just happened like, a day or two ago, you could just tell me what's bothering you, that's fine. Or if it happened a while ago, if you know what your injury is, like I have a herniated disc, or I had a surgery of this type or that type, or I have, whatever it is. And then just tell me your city and your name. You don't have to tell me your whole name if you want to keep it private. You can tell me, for example, my name is Chrissy. I'm from, Philadelphia. A car hit me in the rear and I have a L5S1 fusion. That's enough, and then we could schedule a call. But then I'll have a little bit of information. I'll be able to help you more, give you more positive like feedback and a better evaluation and a better advice, right? That's what it's all about. I want to help you, and then and then whatever you need from there. So absolutely. And then Chris Yaster says, my sister experienced racism from her doctor when she picked up medical records to transfer to another doctor. He attacked her character very badly on her medical records. Yeah, you might be able to speak to a civil rights lawyer about that. Yeah, that could be. I'm not sure, but it could be a case. And Positivity says, what is a good middle number to start with in mediation for a spinal fusion case resulting from a slip and fall in a grocery store? The policy max is 1 million. Well, I mean, if you had a fusion and if it's good liability, you're not worried about the fault issue. It's their fault, like you fell because they left a puddle or they were mopping and they created a puddle. If you're good on the liability, I would just try to get the full million. Why start? Why go down? That's the old school of doing it. Start at a million, have them say $1 million. That's so much money. Are you crazy? You really want $1 million? How about 50,000? And then you feel like you're an idiot, right? Because you're asking for a million, and they're at 50,000. So come down 750. Oh, that's still too much. 600. That's still too much. Okay, well, we'll give you 75. You see what they're doing? And then they want to drag you down, and then they want to settle it for like 150. I actually saw today. I was doing a consult for somebody, and they told me the name of their lawyer, and I was researching their lawyer, and the lawyer like settled the case for a fusion for 150, and I thought 150 for a fusion? Like I'm just telling you, just this week, right? We got a fusion for 2.2 million, and then the last fusion I did was 3.5 million. So I wouldn't settle a fusion for like only 150 unless there was like some kind of problem that's insurmountable. So with a case like that, I would go for the million. Dennis says, hi, what happens after you sign paperwork for discovery? So, discovery is just the entire process, right? When you discover information. So it includes depositions where the other lawyer questions you, your lawyer questions the other side, like the defendants, and you exchange documents. Like, for example, you answer interrogatories. In New York, we have a bill of particulars. Um, you also give them authorization so they can get your medical records. So I don't know exactly which documents you're talking about signing because there's so many different, documents you could potentially sign. But it's the whole process, right? And once all discovery is done, once all the documents are exchanged, once all the witnesses are questioned, then you certify it as trial ready. And then Mike says, had 2 SI joint surgery and C5, C6 surgery unloading a truck on a forklift, and the driver pulled off and lift fell on the ground. Do I have a good case? Yeah, I mean, if you're unloading a truck and you're on a forklift, and then the driver pulls off and so the forklift fell to the ground. Yeah, I mean, of course. Were you saying the forklift was in the trailer and the driver moved and fell off the trailer, or it fell on the ground? I mean, I'm not sure exactly, but it sounds like a potentially great case. 3 fusions? Yeah, I mean, better to text me, 347-566-9595. Then we could jump on a call. It's always free, confidential, and we can do a more detailed consultation, and I could get the exact details of what happened and give you more like insight. And if you have a lawyer handling it, I could tell you the lawyer's prior settlements and prior jury verdicts. Sometimes, they're good. Sometimes I had this one lawyer and did the jury verdict on them, and they had good jury verdicts. I forgot what it was, like 17 million. And sometimes it's bad. Like, people like think, oh, I have the best trial lawyer. Then you do a jury verdict, and it's like, I have 2 cases, or I have 3 cases. 2 are for 0, and 1 is for like 7,000. Today I checked one lawyer, and he had a verdict of 860. So the client says, oh, 860,000? No, 860 dollars. You never know. You never know. You never know until you find out, until you look into it. So I'm happy to do that just as a service, like a I don't charge for that. That's something that I could. I think education and knowledge is important. The more you know, then the better you could do in terms of making decisions and making sure that you're well represented and you get civil justice. It's all about getting justice. Okay, so what he says, yes, and he had a red light too. I mean, yeah, if he moves like that, that's a great case. I don't know where it is, like what city, but if you had an SI joint, a C5, C6 surgery, three effusions, and clear liability like that, I would focus on finding out that trucking company, the one who moved the truck and caused the forklift to fall, because if that particular lawyer, or I'm sorry, that particular truck has, let's say, like, I don't know, 1 million, but then they have like 10 million excess, that case could be huge, right? That case could be like multiple millions, like 5 or more million, if it's worked up the right way. And digital audit says, Arkady, how would you fight a denied claim in contributory negligence state where the driver merged into your lane? So they say you're 1% at fault. Oh, I see. A contributory negligence. So not comparative. Comparative is where whatever percentage you have is the percentage, right? So I could find somebody else like 1% at fault and they still have to pay 1% of the damages. But contributory, I believe, is where you have to show that they're at least 51% at fault, right? Mostly at fault. If they're not 51% at fault, then you get nothing. So I guess if the driver merged into your lane, um, I mean, then why would you be at fault? You're just driving along, you're in your lane, that's where you're entitled to be according to the vehicle and traffic law. And the other car didn't look, didn't see you, and merged into your lane at a point where it wasn't safe to do so because there's a car in the lane. You have to merge into an empty spot, obviously, not into a car. So he merged into you. It's his fault. So I think you could hold him at least 51% or more at fault. So you should be okay. And then Ton Saley says, in 2022, I got sideswiped by a semi truck, and this caused an L4, L5 lumbar fusion. The semi truck admitted fault, and their max policy was 2 million. Finally, getting a deposition done end of the month. How much should I expect? I mean, yeah, if you had the fusion like that with the truck, I would say at least, from 1 to 2 million. Maybe you could take the full 2 million if that's all they have. Make sure that's all they have. Get their all their excess, umbrella, concurrent, supplemental, all their policies, so you could verify that. But that sounds like a good case. And then there's a question: does a verdict mean what they say were able to win at trial? Oh, does a verdict mean what they were able to win? Yeah, a verdict is like what the jury, says the case is worth. So the verdict means the trial was done all the way to the end, right? And then the jury said, like, we listened to this case and we answer questions. So usually the questions they answer are: number one, was the defendant negligent? Number two, was the defendant's negligence a cause of the injury? And number three, if yes to the first two, then number three is, how much is it all worth, right? What are the past pain and suffering, lost wages, medical expenses, and what are the future pain and suffering, like loss of enjoyment of life, medical bills, lost wages, whatever categories you have in your damages. So then if it's a verdict, that means that the jury said it and the trial is done all the way to the end. If it's a settlement, that means, like, while you're in trial, like say you're doing your opening statement, or it could be like in the middle of trial, anytime, both parties just agreed to an amount. So a settlement is sometimes good because you're kind of like guaranteed you're going to get the money. It's kind of like a contract. You shake hands and you're going to get that money. Whereas a verdict, the jury could give you a crazy verdict, like 100 million. Then the other side will just say, oh, 100 million, that's too much. Let's appeal. And then the appeal is going to take 5 years. And then the appellate division is going to say, well, yeah, 100 million is too much. Do the trial again 5 years later. And you don't want that. Well, what's the point of that? Or they'll say, oh, yeah, 100 million is too much. Take, some lower number, like take 10, or do another trial. So that's usually how they do it. And then what else is here? Anar says, hi, sir. I've been waiting for the first offer from Amazon for 3 months. Is it normal for it to take this long? Yeah, I mean, I really if you really want the offer, don't wait for it, like, make it happen. Like I was saying, like, write them a letter. I mean, not you, but your lawyer should write them a letter and say, "Look, you have 30 days. Here's your opportunity. Let's settle it for 1,000,000. If not, then after the 30 days is up, it's gonna be 3,000,000." And that way you put them in the corner, you put the pressure on them because why wait on them? They're a big billion-dollar insurance company or Amazon, I don't know if they're self-insured, if they have insurance, but they're a multi-billion dollar company, one of the richest companies in the world. They might just say, "Hey, let's wait this guy out. Let's not give him anything, or let's give him like pennies on the dollar." And then if you're just waiting on them without any kind of offense, it's like it's not going to work. You need some kind of offense. You need to play offense. You can't just wait and play defense. So I believe in offense. Offense. Okay, and then digital audit says they said I didn't jam brakes. Jam brakes. Oh, I mean when they changed lanes into you, you didn't stop. You were supposed to stop. I don't know. I mean, they always say something. Everybody's always going to say something. But I think if you're in your lane driving and they change lanes into you, that sounds like it's their fault. I don't see how it's your fault. Um, and then Kevin says, can you explain some court terminology like case in a motion and disposed? Yeah, a motion is just when you ask the court to do something. Like, for example, a motion for summary judgment means you want a judgment. A motion to change venue means you're not happy with the venue. Let's say I have a case in Brooklyn and I want to change venue to the Bronx. It means I want them to move it from Brooklyn to the Bronx. So it could be anything. It could be a motion to extend time because I need more time. So just you're moving the court. You're moving or you're asking for some kind of relief. It's also known as an application. And then the court could give you the relief that you're asking or applying for or requesting. So that's just a motion. Disposed just means it's done with, right? It's all resolved, like disposed. It could be settled, disposed. It could be dismissed, disposed, but it's disposed of. So it means it's whatever issue or case. If the case is disposed, that means the case is done. That means if you want it to do something new, you'd have to make a motion to restore it because it's like disposed. Just like if I take a piece of paper and I throw it in the garbage, right? It's disposed. So it's the same kind of thing. Lost in Awareness says, have you ever done an IME for your client to support your case? Well, I've gone to IMEs with my client, sure. Like when an IME is when the defense medical examiner is going to examine my client. So I've gone with the client to the IMEs and I've taken notes, but it's not always so good because if I'm the lawyer that's doing the trial, you don't want me to be the watchdog at the IME because then I can't, unless I would have to then testify, I would have to get another lawyer to question me, right? Because I'm the witness. So the best way to do it is just to hire like one of these IME watchdogs and then they're like independent watchdogs. And that's what they do. They show up to these IMEs, they sit there and they write down everything. Like the doctor walked in the room, the doctor, lifted his pen, the doctor asked this question, everything, like a transcript of everything that happens and how long it takes. And then you could use that to then cross-examine the doctor at trial. Those things work pretty good. And Jarrell says, a driver ran the stop sign, hit me. I had a spinal stimulator inserted. They have a commercial policy. What are my chances with this case? Yeah, I mean, that sounds like a great case. If the driver ran the stop sign, so he's 100% at fault, it's a commercial policy. Find out how much it is. Is it 1,000,000? Is it 5,000,000 excess? And a spinal stimulator, that's a serious injury. But you would have to, review your medical records. Like, why did you have it? Did you have any kind of surgery as well? Was the only procedure just the spinal cord stimulator? Was it for a specific type of nerve pain, herniated disc? You'd want to have the medical diagnosis because the spinal stimulator is a device to help you feel better. But why did they need it, right? Why did you need the device? Just like if I say I'm taking a certain drug, right? Like somebody's taking, I don't know, like Tylenol or another drug, a prescription drug, like what are they? Xarelto or Jardiance or whatever drug. Well, why are you taking the drug, right? You have an underlying condition, whether it's like diabetes or it's a Tylenol because it's a headache. So you want to know what the underlying condition is. And then once you know that, then you're able to develop the case and make the case stronger. But text me. I'm happy to chat. 347-566-9595. And then Irish says, thank you for all your helpful information on 321. We were rear-ended while we were I think it cut off somehow. I'm not sure what cut off. But yeah, just text me 347-566. Yeah, I'll drop it in the chat too for everyone. That way you could text me Just text me like the facts, the injuries, and your city, and I could give you a consult. Actually, I'll be around like today. I could do a few calls today, tomorrow, um, and then definitely like next week as well. And then Dennis says, "Can you settle in a deposition?" Yeah, you can. You mean like during a deposition? I mean, you can. I mean, usually like they don't really do it in the deposition because the way it works, right? The defense lawyer probably has some authority. So as the defense lawyer is conducting the deposition, he already has authority. Let's say like well, I had a one case. It wasn't the biggest case, but the defense lawyer, was about to start the deposition, and it seemed like the case had some issues, and he said, "Look, this is going to be a long deposition. This is going to be 7 hours. But if you want, instead of doing the deposition, I have like 50,000 in authority. I could just settle the case right now for 50,000." So if you thought like 50,000 was a fair number, you could do that. Or if you thought, "Look, let me give my deposition. Let me really explain what happened. Let me fix all these issues that they think are issues. Maybe they're non-issues." Then look at it again with the adjuster, and it's not really 50. It's more like 150, and you can get more, then do the deposition and get more. So it depends. But you absolutely can settle in a deposition. Yeah, there's no reason you can't. Absolutely. And Lost in Awareness says, "My lawyer scheduled an IME for me because he said that's going to be the expert witness in my case. I just thought it was weird because I thought that was a defense tactic." Oh, I see. Schedule. So probably that means that your doctor is not available, maybe? Because usually you would use your treating doctor. But if your treating doctor is not available, like if they're, retired or sick or whatever, just not available, then you could do an IME where you do an independent doctor, almost like I wouldn't really even call it a IME. It would be more like an expert where they would just review all your medical records and give you an evaluation, and then that doctor would testify. It's not as good. I prefer using a treating doctor. Maybe if you need an IME doctor for a certain specialty, like you need an IME doctor for, let's say, orthopedic, because your orthopedic doctor is like sick or not available. So that's fine. But what I would do is I would call some other treating doctor, like pain management. So you have a treating and an IME, not just an IME. Because if you just have an IME, then you're on the same playing field as the defendant, because all they do is call an IME doctor, right? And that doctor sees you for like one time for like 10 minutes out of your whole journey, right? From when you got hurt up until the time that your case is over, they see you one time for like, 5, 10 minutes. So that's the whole cross-examination about them, is to say, hey, you don't really know the client, you don't really understand the human being, the patient, because you only saw them for this one moment in time. But if you have the same evidence, then it's not as persuasive. Then they could say the same thing about you. You've been treating for whatever 5 years, and all you could show us is one little sliver in time of 5 minutes. Where's everybody else? And then you feel like you don't have enough evidence. So I think if you have to do that, you can do that, but also have treating doctors, because there's no way all your doctors are not available, right? Probably it's one specialist. Like if it's orthopedic, you can get an orthopedic IME, but then what about neurology? What about pain management? What about physical therapy? So you could find some doctors. Okay, everyone. I hope this was helpful. I don't think I see any more questions, so I guess we could wrap it up for today. But we'll do another one maybe next week, and I have other videos coming up. I have a video about jury selection. Actually, it's really interesting. It's jury selection, and it's some gems on how to pick a fair jury and how to think about jury selection. And it's also a CLE, a continuing legal education, from Jerry Spence, like the famous trial lawyer, Jerry Spence. So I have like a two-part series on that. I have one about electrocutions. I'm going to do one on spinal cord stimulators and some other jury verdict searches. But like, let us know what questions you have. Like and subscribe to our channel. Feel free to ask us any questions. Just text me 347-566-9595. And we are here for you. Our goal is helping serious injury victims and families. Okay. All the best, everyone. Bye-bye.